Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. I'm Kirsten Howe, the managing attorney at Absolute Trust Counsel, and we're glad that you're here today to listen to this episode of my podcast. My guest again today is Janet Brewer of the law office of Janet L. Brewer, located in Los Altos. We had Janet on our last episode. Janet is a certified specialist in estate planning and probate. A significant part of her practice is international planning with clients who have some sort of international issue. And so I wanted to have her on to talk about some of those issues. And in our last episode, we were kind of focused on guardianship and all the issues that arise when there is an international situation. So go back and listen to that if you are curious about guardianship. But today we're going to talk about some other issues in international estate plan. And in particular, let's start out, Janet, if you will. And first of all, welcome back. I'm glad to have you.
Thank you.
Let's talk about a kind of a common situation I think that you encounter. I see it less, but you're over in Silicon Valley. So your client base is a little bit different from mine generally in this regard. But you have a lot of clients who are here on visas and they're working, they're earning good money. That situation can present a particular planning opportunity, let's just say.
Okay, well, as you said, I'm in Los Altos, which is the center of Silicon Valley. A lot of my clients are here on visas. Some of them have green cards, but a lot of them have visas. And they've got stock options or RSUs. So my typical international estate planning client isn't one that a lot of people think about. It's not necessarily that the estate tax right now doesn't affect most people until they have over $13 million, almost $14 million. But with a person who's here on a visa, the estate tax can affect them with as little as $60,000. But there are a lot of ways around that, things that are not counted in coming up with that amount of money. So one of the things that they encounter if the company is successful is what happens with their stock if something happens to them. And this is an area where, again, international estate planning is a little different. For a U.S. citizen, the IRS says anything you own any place in the world is subject to estate tax. In international estate planning, the rules are different if you're dead or alive, and also where the assets are located. So the person has the RSUs, they exercise the RSUs, and God forbid they pass away. If they pass away owning the shares of stock in the company that they owned, those assets are part of their estate for estate tax purposes. If they gift those same assets while they're alive, they're not subject to gift tax. So this is a common situation that I run into. The children in the United States are suddenly worth a lot more than their parents are, who live in another country, and they can afford to gift them, what we would consider to be a large sum. They can gift them $500,000 or $1 million worth of stock and not have to worry at all about any kind of estate taxes or gift taxes on that. So that's something that I guide people in doing when they want to take care of family members that are overseas and they're here primarily on visas. There are some ways that you can do that if you're with a green card, but for the most part, a green card holder falls under most of the same rules that a U.S. citizen does.
So your client is the person who's here on a visa working for a U.S. company, issued RSUs or stock options, whatever it might be, might make sense to gift that while they're alive to their parents back in their country of origin for tax reasons.
Correct. Assuming that, obviously the issue that all of our clients have is, making sure that there's enough for themselves.
Can I
But
afford to do that?
Can I afford to do that? But, I've had a number of clients who are Silicon Valley success stories. They've gone from a couple of $1 million worth of stock to all of a sudden it's now worth $10 million to now it's worth $40 million. Now it's worth $100 million. So although it's not frequent, it happens enough times that if they can give that away without having it be subject to tax, that is definitely something that they want to be able to do. And they do want to help mom buy a home or, have a more comfortable retirement.
Sure.
And our money, the dollar goes a lot further in other countries than it does here. So what we might not consider enough to live on for the rest of our lives can make a huge difference in the lives of loved ones back in a different country.
The example you gave is let's send $500,000 worth of stock back home. And you said there's no estate tax, no gift tax, because the person doing the transferring is not a U.S. person. They don't have a green card. They aren't a citizen. And is there no limit at all? They could be sending $100 million worth of stock back home?
That is correct.
This person's not subject to U.S. gift and estate tax laws?
Not exactly.
Okay.
They are subject to U.S. gift and estate tax laws. It's just that the gift and estate tax rules are a little bit different.
For them.
And it has to be a person who is not a U.S. The legal term that we use in the international field is domiciliary. So you can be a U.S. resident for income tax purposes, but you are not necessarily a U.S. domiciliary for estate tax purposes.
Oh, okay.
So it's just one of those little minor distinctions. Basically, if you remember back to law school, the good old international shoe case, you can have many residences, but you can only have one home.
Got it.
So a domicile is most easily translated into what do you consider your home?
Where is your home?
And one of the things in order to get a visa in the United States that you have to do is swear that you are not going to make the United States your home. So because it's not your home, there are some loopholes that you can take advantage of to transfer wealth outside of the country. But again, they're different. U.S. stock for gift tax purposes isn't subject to gift tax, but that same U.S. stock, if you die owning it, is subject to estate taxes.
Okay. Yeah, we're really kind of nerding out on that. But
Yeah.
but it's an important point.
There's a lot of planning opportunities that work around that.
You use the term loophole, and that's probably how the general public sees it. But the way we see it is it's a planning opportunity. There's a disparity between what's income taxable and what's gift taxable. Take advantage of it.
Right. And as you and I both know, the advantage isn't as great as it was a number of years ago when the estate tax rate was a lot higher. But again, from the perspective of the person that's here on a visa, they've only got a $60,000 exemption versus a $13,990,000 exemption this year.
Right.
So that can be a tremendous opportunity. And the tax rate is high. If you're a non-domiciliary and you have an estate of $1 million, you're going to pay $345,000 in estate tax or gift tax. And it's 40% of everything that's over that. So a $5 million estate is $345,000 on the first million, and then $400,000 on each additional million. So that's another 4 times 4 is 1.6. So you've got 1.6 plus 345. You've got almost $2 million of estate tax on a $5 million estate. And while in this area, people don't think that they're millionaires if they've only got $5 million, the truth is that they are. And you don't want to see roughly 40% of that have to go to taxes because you haven't planned well.
Right. Yeah, and a $5 million estate owned by a U.S. citizen would not be taxed at all.
Exactly.
Yeah.
Exactly.
So it's a big distinction. Janet, one of the things that I know we have to be mindful about when our clients have family members back home, and they maybe want to include them in their estate plan, is the issue of who should be the trustee of our client's trust. You want to talk a little bit about that?
Yeah, I'd be happy to. I get questions all the time, or I get people who come in all the time who say, well, I want my sister who lives in name the country to be the trustee of my trust. If that happens, there's nothing, as I tell people, it's not illegal, it's not immoral, it's not unethical, but it can be very costly. If you have a person who is a U.S. citizen, and again, sometimes green card holders fall into this category as well, if they are what we would call a U.S. person who have a trustee who does not live in the United States, then you can get into what the IRS terms the foreign trust rules. And the foreign trust rules end up potentially costing the beneficiary a lot of money in taxes. So you have to be careful when you do that. I do have clients that say, you know what, I don't care. That's still the best person to be in charge. That's the person that I trust. And again, it's not illegal. There is a tax cost to be paid. But, you know, the government is more than happy to have you pay that tax cost. So if it's okay with you, it's certainly okay with them. But there's actually some other practical problems that you get into these days. Kirsten, I don't know if you've run into this or not, but I'm finding with my clients who live overseas, U.S. citizens living overseas are having a difficult time either opening or maintaining bank and brokerage accounts in the United States. I think, are you encountering that?
I don't know that I have encountered that, but that doesn't surprise me. And that's interesting. Yeah. Okay.
Yeah, there's so much concern about money laundering,
right,
that the banks are reluctant to have any account holders who don't live in the U.S.
Yeah, and that's not because of any law or executive order or anything. It's just a bank by bank policy. We don't want to get caught in this. So we're just not going to take any of those kind of accounts. Yeah.
Right. I'm not 100% sure of this, but I think that there are also reporting requirements that they have to meet if the account holder does not have a U.S. address. And I've been told, I don't know this for a fact, but I've been told that the banks and the brokerage firms are actually getting sophisticated enough that you can no longer use a post office rental box with a street address. They know where those places are located. And if they see that your address is 123 4th Street, apartment 22, they know it's box 22 at the local rent a post office box store. So it's getting harder to maintain these accounts, again, just as a practical matter. If you have an overseas trustee, again, there are reporting requirements. The banks in the other countries have reporting requirements into the United States. I have some clients, and I'm not recommending this, but you know, it is something that I'm seeing clients overseas do, where again, if the child is living overseas, they're actually just giving the account outright as a gift to the child's guardian and trusting that that guardian is going to use the money for the children. That can be a very dangerous way to go because certain countries have what are called forced heirship rules, where if the guardian dies, they are required by the law of their country to give X percent of the estate to their spouse or to their children or to their spouse and their children. And even if they've set up a will that says all of this money goes to my brother's children, it's not going to be enforced.
Not enforced. Yeah. Okay. That's an interesting point. Okay. So avoiding a foreign trustee is financially oftentimes desirable. It may not work for the family because the people that they trust are foreign. But I suppose alternatively, we're always going to talk to them about, well, you could just hire a U.S. trustee and, you know, be done with it. Of course, that's not a person that you necessarily know or trust, but, you know, those are the benefits of having licensed professional fiduciaries here available. So that's a consideration, I would suppose.
Yeah, I mean, and again, I know you run into this in your practice all the time. I mean, people do have a preference for having family member trustees. But there are a lot of times when it makes sense to have either a corporate trustee or a private professional fiduciary as the trustee.
Right.
And frankly, this is one of them. It just makes things easier, at least from a tax standpoint. And again, a lot of my foreign clients don't have 20, 30, 40, 50 million dollars. So saving a few $1,000s from taxes each year can make a big difference in terms of how much money there is available to take care of their children.
Right. So it's at least something to consider. And
Right.
again, pluses and minuses laid on the table, client makes the choice. Yeah.
Exactly.
Okay. So there's one more thing that I want to talk to you about in this episode, which is when somebody, let's say in the US, dies and the beneficiary who's inheriting their money is in another country, is not a US citizen, they are in another country. Are there particular hurdles that person is going to have to go over, or the trustee of that particular trust is going to have to jump through certain hoops that we wouldn't have to if our beneficiary was here in the US and a US citizen?
Yes, there are. One of the biggest issues, again, I'm going to go back to the bank and brokerage firms. They will not release the money to someone until they get a form from that person, that includes either what's called a social security number or what's called an international taxpayer ID number, an ITIN. Because again, going back to the example of stock or actually even money market accounts, the money market account or the stock isn't paid out on the day that the person dies. So between the time that the person dies and the time that the money can be collected, it may have earned interest or it may have earned dividends. And with interest and dividends come income tax.
Right.
So the brokerage firm has a responsibility to make sure that the income tax is paid to the U.S. Treasury. And what they want in order to do that is someone's social security number so that they can prepare a 1099 that ties that money that was sent in to the recipient. Most people who live outside of the United States don't have social security numbers unless, they worked here in the past, or again, they're a U.S. citizen who's now moved overseas. So with a social security number, that's not a problem. But if they don't have a social security number, they have to get this ITIN. And it can take a couple of months to get that. Once upon a time, you had to actually make an appointment with a U.S. consulate or a U.S. embassy in the country where you lived. And that consulate or embassy wasn't necessarily close to where your residence was.
Right.
I don't know if this happened pre-COVID or post-COVID, but I've certainly heard more about it post-COVID. There are now agents. You can actually go on the IRS website, and there are people that they have designated in different countries who have the authority to actually apply for an ITIN on someone's behalf. But it costs a couple of $1,000s typically. The most that I know that there's one firm at least out there that charges $5,000 to do this.
Wow.
Just to get the ITIN.
Just to get the number.
And quite frankly, the form isn't that much more complicated than the W-9 form, but it's basically use us or travel to the embassy and wait for 3 months for an appointment. Do you want it next week or do you want it next year?
You're right. Yeah.
So you're paying for the convenience.
Yeah. That's a legitimate business opportunity.
Yeah. I'm going to actually switch things up just a bit to something that I actually wasn't aware of until recently.
Oh, yeah, I'd love that.
So let's assume that you've got a U.S. citizen living outside of the United States who has assets back here in the United States. Let's do something that a lot of people have. I'm actually dealing with probate right now where the woman that passed away had moved to England about 15 or 20 years ago. But when she was in the United States, she had been a teacher. So she had, a 457B? No, it's 403B, 457, whatever plan.
Right.
And, she had several $100,000 in it. Her beneficiaries are U.S. citizens living in the United States.
Okay.
Okay. We're having trouble getting the money out of the brokerage firm and transferred into a rollover IRA because, and I didn't realize this, even in a non-taxable situation, and her entire estate was probably worth, well, I know it was worth less than $2 million, including all of her worldwide assets. So she's no place close to the $13 million threshold for a U.S. citizen. But there's an IRS requirement that says that when the decedent is a U.S. citizen not living in the United States, you have to get what is called a transfer tax certificate from the IRS. And it's actually a rather convoluted or a rather involved procedure. The first step is you've got to get a death certificate issued by a U.S. embassy. There's a form that you get that is the report of a death of a U.S. citizen living overseas. You have to get that. You have to actually, even though you're not subject to estate tax, you have to pretty much put together the same information that you would have to for an estate tax return.
To prove there's no tax.
To prove there's no estate tax. The IRS wants basically a date of death balance sheet showing what the assets and the liabilities were. And then you have to apply for this transfer tax certificate. There's a couple of other requirements as well that I can't remember. But then you have to apply for the transfer tax certificate. And the IRS website itself says, and this is pre-COVID, it says it ordinarily takes us 6 to 9 months to provide the transfer tax certificate.
Oh, okay.
So people who are living overseas who think that, oh, no problem, I've got assets in the United States, they've got beneficiaries named on them. Frankly, even if they've got a trustee on their trust, the banks and brokerage firms are not releasing the money at this point without the transfer tax certificate. Again, this is kind of a practice tip for you. There is a way around it. They will release it when there is an executor appointed.
Oh, so we're going to open a probate.
So you can open, I mean, now you and I will know the meaning of this. It will probably be a dry probate.
Right.
But you can open a probate because then the IRS has a person located in the United States who's on the hook for any unpaid taxes.
Right.
So this is, again, even when the beneficiaries are located in the United States, it can be a problem.
Interesting. Okay.
For someone who lives overseas. And I hadn't actually encountered this until recently. So.
Okay, well, and now we all benefit from your hard-earned experience. That was interesting and fascinating. And thank you for that tip at the end. And Janet, I'm just going to say thank you again for this episode. Then the prior episode, we learned a lot. We covered a lot of material, and I really appreciate you being here.
Thank you. It was a pleasure.
All right. And thank you all for watching, listening, thinking hard, and following along. We look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.